Gentlemen. Hush. I want to welcome everybody to the House Public Safety Committee. We've got 3 propositions in front of us today. Anyone got their cell phone in their pocket? Cut it off. Mute it. Thank you. All right, first up, Senator Kirk. This is a continuation from last week, and you were working with some of the committee members. I think y'all come up with some new language.
Yes, sir, Mr. Chair. Glad to bring before you this substitute, and we have continued to work. I've worked with Commissioner Neal and some of his staff at CJCC, and so what you have before you is a substitute with some language, and we'd like to make 2 more changes, and I think we have this perfect as it could be. So I'd like for me to take you through those changes, Mr. Chair.
Please.
On line 45, if after it says to provide technical support and assistance for grant writing, let's put a comma there and put subject to appropriations and then another comma, and then it'll continue to read to any local law enforcement. And then on line 49, just strike grant funding. We felt like that was redundant because we are requesting funds for grants for equipment and training and different things. So just strike grant funding, add that subject to appropriations, and we have a perfect bill in front of you. I'll answer any questions that the committee may have.
So you're adding comma after writing on line 45, subject to appropriations, strike on line 49, strike grant funding.
Yes, sir. That's correct.
Nothing else to be added?
Nothing else to be added, nothing else to be taken away.
All right, committee members. Questions? Yes, sir, Ms. Hall.
Thank you, Mr. Chairman. Senator Kirk, what would be the process by which the council will find that such local law enforcement agency would otherwise lack access? Do you have any guidance on how that will be carried out, lines 46 and 47?
Well, it will happen as a call, and they say, we need support. We got a grant we're wanting help with, and we need some help writing that grant. So like I gave a example of my police chief in Abbeville, Georgia, who was doing 15 different jobs and trying to write a grant at the same time one day when I walked in. He may need some technical support, so he lacks the access that he needs to have his own grant writing staff or assistance with grants. So they will be contacting the agency. The way I envision this taking place, this will begin July 1, and the agency will begin to track how much volume they're getting from cities and counties around the state, and then they will come back to us in January and say, you know what, here's the volume. We might need 1 staff person to handle this, or we may need 2 staff people. We just don't know those things yet, but that's the way I envision this taking place.
Okay. Thanks.
Yes.
Other questions, committee members? Other questions? All right, since this is the same bill we did last week, we are going to take some, if anyone wishes to be heard or to testify on this, if you would raise your hand. Good for y'all. Good for y'all.
Told you we perfected it, Mr. Chair.
I understand. Is Mr. Neal in the room?
No, but there are some people here from CJCC. Oh, Mr. Neal is in the room. Okay.
You like this?
Yes, sir.
Thank you. All right. Let's see, who is, Ms. Frazier? All right. Do we have anyone else who wishes to be heard? All right, committee. What's the feeling of the committee? We have a motion. We have a second. Further questions? Secondary motions? None. All in favor say aye.
As
Do
amended.
pass as a substitute. All right, let me back up. Do we have a motion on the bill? And a motion do pass for the substitute. Any substitute motions? If not, all in favor say aye as a committee substitute. They have it. Thank you, Senator.
Thank you, Mr. Chair. Thank you, committee.
All right. House Resolution 1341, Representative Cox.
Thank you, Mr. Chairman, members of the committee. The House Resolution 1341, I wanted to get in front of you guys and let you begin pondering this in the likely or unlikely event, depending on your perspective. I return here next year. I want to pursue this measure. This is just one of many ideas on how to do something about really funding and creating options for enhanced school security and safety. And this would create the Student and School Safety Fund. It will also allocate monies to it by collecting a surcharge on fines paid in our state. It has accompanying legislation that is fairly vanilla. We've done a lot of these things, as Chairman Powell knows all too well. It would create a board for that particular fund, and then school systems would then be able to petition the fund for monies to enhance security, including security devices, security systems, cameras, that sort of thing, as well as school resource officers, and even training and arming qualified faculty members as determined, under current law, as determined by the school systems themselves. And that's really all the measure would do.
All right. Any questions of the committee? Does anyone wish to be heard? I'd like to sort of deviate from this. I'm going to ask Ms. Nesbitt if she could come up, and she didn't come here to do this. And she's employed by the Association of County Commissioners, but in her role in a previous life, when she was working with the administrative office of the courts, there were some problems, and for the life of me, I didn't mean to get into this, but we have so many surcharges right now, so that average penalty, like there was a certain bill that hit the floor last week, there was a $300 fine. I think it had something to do with using a cell phone.
Yes, sir.
And the question was asked, did they compute the surcharges into it? Well, that fine would be a little over $500 for the first offense. And so, you know, that's something that I've known about for years. Some of us has harped and we've griped about it for years. A lot of those surcharges that go into certain funds, I don't know when there was an audit done at last, how much is an over surplus of money and such as that. And I'd like to ask Deborah, and I hate to put you on the spot, Deborah, but if you'll search your memory, could you maybe tell the committee a little bit about all of these, the different surcharges and the things that go on?
Well, there are a total of about 20, I think, that can attach to a criminal case. And they fund a number of different things: retirement programs, brain and spinal injury trust fund. You know, there's a number of things, and there have been audits over the years, but they're mainly what they're auditing is to make sure that the fees are being calculated in the right way at the local level, and that those monies are being remitted. I don't know that the beneficiary programs is what we call the people who actually get the money. I'm not sure about how often or how frequent they are audited to find out how they are spending the money. So I know that the actual collection of the fees and the calculation of the fees have been audited in the last 10 years or so, but I don't know about with the beneficiary programs.
All right. Would anybody, this is your chance to ask a real expert that knows a little bit about this. If y'all have, if any committee members want to ask her any questions, maybe she can answer them, because if she can't answer them, I don't know anybody that can.
Well, thank you, and I hope I can answer them. Any questions?
No?
Thank
Mr.
you.
Holcomb?
Thank you, Mr. Chairman. I get the idea behind the bill, but I think some might argue that this should be something that should just be funded either by state dollars or local dollars, just period. If the issue is school security, then that's something that's important, and that's not something that should be added on to tickets as a surcharge, but something that everybody should pay for.
Well, and not to put Representative Cox on the spot, but ACCG and GMA both really don't want to see any more fees, for the reason that it takes away some of our ability to use revenue in a way that needs to be used at the local level. So yes, I think it probably could be funded out of the local school system.
And I imagine some districts are looking at exactly that, correct?
Yes, I would think so. And that's a separate taxing authority, so we don't typically get into the education part or the schools part of it, but I would imagine that they are.
Right.
And I know there are several things out there right now, like cameras in school zones for speeding that will generate some revenue, and there has been some talk of some of that maybe being used for that specific purpose.
Thanks.
Thank you. Any other questions from any of the committee members? Ms. Frazier?
Yes, sir. Thank you, Mr. Chairman. I just want to know, who's asking for this? Is this the school system?
I'm asking for this.
Oh, sorry. Thank you.
No, look, I think that everybody believes that we need to be proactive in finding ways to allow our school systems to take the measures to make their kids safer. And the idea behind this is there a way, is there a mechanism to create a perpetual means of funding versus the annual sort of trying to allocate and appropriate funding, so that there's a pot of money that local school systems can decide what's best for them, what's the best fit for their schools, if anything, and then apply for these funds to enhance their own security.
Other questions? No other questions from the committee. Does anyone wish to be heard on this matter? Out of an abundance of precaution, since we've still got plenty of time, the committee's going to hold this bill right now, and I would implore the committee members to, if you've got any time, you need to reach out to see some of these other, some of the other surcharges and what they go for and such, and to ask some questions. One of the concerns that I've had for years is that probably one of the levels of disrespect for law enforcement is that when they think when somebody thinks they've done wrong and they think they're going to be online for a normal fine as a penalty, and all of a sudden they get the breath-took slap away when they finally get the final
Right.
final addition to their fines. And that's something I think we need to take a good look at. But for the committee, if y'all would, before we visit this bill again, y'all need to consider some of this. Thank you,
Thank you,
Representative.
Mr. Chairman.
Appreciate it very much. Last but not least, we have House Resolution 1416. Representative Carter, if you would, come on up.
Well, good afternoon. Thank you, Chairman and committee, for allowing us some time to present this resolution. Before you, you have House Resolution 1416. It is a study committee on bail reform here in Georgia. And just to give you a little background, the Georgia Legislative Black Caucus had their retreat late last year, and we were having conversations around some legislative priorities, and bail reform was one that came up, and I raised my hand to support that effort. And so we had been working since the session started to look at some legislation that we thought would be positive to bring forward. But with the time that we had to work on it, we really thought we'd do a better service by doing a study committee to really take our time to really look a little deeper into bail in Georgia, and then looking at ways that maybe there are some alternatives to individuals being in jail that is very costly to the state. And then through this study, we'd like to also explore some opportunities for if there are some funds that are freed up by individuals not being in jail, looking at ways that we could do some community-based programs that will improve community health and safety. So Basically, we're asking you to approve a study committee in the House that we can study this subject of bail reform. And I have a few people that would also like to speak, and so basically that's what we're asking.
All right, do we have any questions from any of the committee members? All right. We didn't have a sign-up sheet. Do we have some folks that wishes to be heard on this study committee?
They actually is.
Well, then just get in line and file on up here then.
You ain't stay up here, get out the way.
No, they can come up here, and if you would just step aside, because if you would just step to your right, because you might need to be, you might want to take some of them to task if they ain't speaking the tongue you'd like to hear. Yes, ma'am. If you would identify yourself, please.
Yes, sir. Good afternoon, Chairman. My name is Marissa Dotson. I'm the Public Policy Director at the Southern Center for Human Rights. We are here to ask you to support this resolution. I come on behalf of this organization. Southern Center for Human Rights has been committed to pretrial justice for individuals in the state for many years. You may recall that we have had some examples of our litigation in the news lately. I actually brought some copies of an article about bail in the city of Atlanta that I would be happy to share with you all. But I wanted to give you some examples. Thank you, Representative Carter. I want to give you some examples of how bail is working in Georgia and some of the problems that we see. You may recall that the Southern Center brought litigation a few years ago, Walker versus the city of Calhoun. This was a case where a gentleman, 54-year-old man who was homeless, walking down the street, was arrested for pedestrian under the influence of alcohol. He was held in jail for many days because he was unable to pay the $160 bond amount that he was given. The way that it works, for those of you who may not know, is that courts are authorized to create bond or schedules, allow individuals to get out of jail immediately if they can pay the amount that correlates to their offense. In this case, Mr. Walker was not able to, and it took him a very long time before he was able to get before a judicial officer. In September of last year, a gentleman by the name of Sean Ramsey was arrested in the city of Atlanta for holding a sign that said, "Homeless, please help." This is against an ordinance that says you cannot solicit for rides or for money. He was given a bond amount of $200, and he was held in jail for 2.5 months because he was unable to pay this amount. It wasn't until our office submitted a petition on behalf of Mr. Ramsey that the charges against him were dismissed and he was released from jail. And then finally, I will tell you about a gentleman by the name of Randall McCrary, who was arrested in October of last year. He was arrested for yelling obscenities at someone in a gas station. He was arrested for use of fighting words. He was given a $500 bond, and then he was unable to make it. He also sat in jail for several months before an anonymous donor actually put up the money for his bail. The issue as we see it is that money is stopping people from being able to get out of jail. We think that Southern Center has been involved in the study committees on this issue by the executive branch with the Council on Criminal Justice Reform. We've also been involved with the Judiciary Study Committee on this issue with the Ad Hoc Misdemeanor Bail Reform Committee. We know that there is a piece of legislation that's traveling through now, Senate Bill 407, which has some of the recommendations that the Council on Criminal Justice Reform made with regards to this issue, but there were some things that were not included in legislation just yet. One of the recommendations that the council made was to create a study committee to look into some of these issues around the way money is being used in our bail system. We think that this resolution is in keeping with the Council on Criminal Justice Reform's call to look at this issue in a meaningful way. I wanted to just quickly let you all know, if you didn't, that the city of Atlanta has recently passed legislation on this issue to try to deal with the way that people are held in their facilities for low-level offenses, and have eliminated cash bail for a certain set of low-level offenses that are nonviolent. We think that there are some things that the General Assembly could look at. What are some ways to make sure people could show back up to court? Around the country, there are programs that are being used for court notice reminders on the text messages that have proved really successful. Actually, recently in Pickens County, there was a study done on how do you improve people's court attendance by court notice. And so they haven't had an intern that's job it was to call up people who had court the day of and the day before and the day of court. And they saw that their failure to appear rate dropped significantly. We're talking about by like 25 points or so. So there are some things that can be done to get people to distinguish between people who are forgetting their court date and those who are really absconding justice. And we think a good look at some of these issues would be very helpful. With that, I will take any questions, but I appreciate the time.
Any questions from any of the committee members? If none, thank you, ma'am.
Thank you so much.
Yes, sir.
Thank you, Mr. Chairman. I've been involved in this for a little while. I'm in a leadership training program called Leadership Atlanta with a lot of business executives for the region. And one of our class commitments is on cash bail reform. And I think what interested us was the potential savings. We've been working with Justice Boggs, who has led the criminal justice reform now for 8 years. As well as the floor leader, F. Stration, who has led these. And the consensus, and you'll see it in the Governor's Criminal Justice Reform Commission, was that we need to do more on cash bail than the bills that are coming out of the Senate this year. And that was based on a lot of things, but overarching theme was that we can save money. We can save money at a state, and we can also make sure that someone who's picked up for a $200-300 fine or failure to appear, which Lord knows probably already almost happened to me several times, is not incarcerated and loses their job while they're incarcerated. It just makes the system so much worse. And some of the reforms are very common sense. As Marissa Dodson said, we can do text message alerts to make sure that people get to jail or get to court when they need to be at court, so we can save tens of thousands of dollars in amounts we would spend to incarcerate someone while they lose their job just because they needed to be at a place on time and pay a $200 fine. So this is the number one priority from the Criminal Justice Reform Commission was to establish a study committee. And it just so happens that the Georgia Legislative Black Caucus had suggested the same thing. We're so pleased it's before y'all. That we could take a look at that and do this in a more in-depth fashion. And the final thing I'd want to say is, we were established as a debtor colony, right? We were established as a chance for second chances so that people didn't sit in jail because they owed a little bit of money. So I think it's in keeping with the promise of the state that we at least take a very good look at this, and this is what this resolution would do. I'm happy to answer any questions.
Any questions from any of the committee members? Thank you, Representative.
Thank you.
Yes, sir.
Thank you, Mr. Chairman, members of the committee. My name is Burrow Ellis. I'm the political director of the ACLU of Georgia. And I want to be respectful of your time and not repeat some of what you've already heard from the preceding two speakers. But I do want to share that on early Friday morning, the ACLU and ACLU of Georgia filed a lawsuit against Glenn County and 3 of its officials, the magistrate, the sheriff, and its contracted public defender, for predetermined bail schedules without taking into consideration a person's financial status. And that's a constitutional violation. The result is that people who can you hear me okay? I feel like I'm going out. The result is that people who cannot afford to post bond are jailed. And you've heard some examples from Ms. Dodson's testimony, but I also want to share the example of Marjorie Frieda Mock and Eric Scott Ogden, who are both homeless and both are plaintiffs in the litigation I mentioned. They were arrested last Wednesday on a misdemeanor charge of criminal trespass while trying to visit Mr. Ogden's grandmother at a local motel. And they were both jailed because they couldn't afford an automatically preset bond in the amount of $1,256. And so the ACLU of Georgia therefore supports the creation of a study committee to determine whether bail reforms are having their intended effect. We met with the Legislative Black Caucus in December and shared that sentiment. And of course, the intended effect is to ensure that no one's freedom is denied simply because they don't have enough cash in their pocket. We encourage that this process, including the appointment of the members of the committee and the work of the committee itself, be open, transparent, and bipartisan. And we also would like to encourage that community groups such as the ACLU of Georgia, the Southern Center, and so many other groups who've been engaged in the work thus far continue to be relied on as sources of information gathering. And that's to ensure that there is, in fact, continued integrity in the process. And with that, I'll close unless there are any questions.
Questions from the committee? Y'all seem to be pretty good at this.
All right, I thank you for your time today.
Thank you.
Thank you, Mr. Chair and the committee. For all of the social justice issues that bail reform touches on, I'd like to just get right to the point that monetary bail is not effective. It just does not work. As House Resolution 1416 says, 64% of those incarcerated in Georgia have not been convicted of a crime. So those with means are not more likely to be innocent of the crime they're accused of, just by virtue of not having those means. And conversely, those who are not financially well off are not more likely to be guilty of a crime because they've got less money. So unfortunately, the way that our state code has it, this is the implicit assumption of the cash bail system that we have, and it's not making us safer. We should, in fact, be determining who is a danger to society based on risk. And there should be a great deal of evidence to support our ability to do that with actuarial risk tables. This is not a bold, unproven idea. As I would love to point you to, other people have said, the city of Atlanta has already made impacts on this opportunity this past year. But there are several other states that Georgia can become a peer of. I've gotten some information from the NCSL about what other states have been doing on the issue and how they're keeping dangerous offenders in custody once they're found to be ready to be in custody. So for example, Kentucky and South Carolina are examples of states that have significantly reduced their reliance on cash bail, specifically through legislative measures. I'd be happy to share that with any of the committee members. They have ultimately been leaning on pretrial supervision and diversion programs. There's also other states in the South that have been dealing with statutory least restrictive conditions. They have language in there that makes it so that you're able to understand through a least restrictive model. Additionally, if we're able to eliminate bond schedules or to make uniform bond schedules in the state of Georgia, that's an issue that the study committee could deal with. When you think about pretrial risk assessments, these are opportunities to connect people with resources that they're actually looking for. So if we're looking at circumstances related to offenses with drugs, people could actually be placed into some sort of risk assessment that shows that the best thing for them would be to get some therapy. So I'm just here to also say that I'm thankful that Senate Bill 407 has a good understanding. I mean, it really speaks to the fact that locking someone up under the presumption of innocence actually creates higher costs to taxpayers, because the median bail in this United States is actually $10,000. We've heard a lot of numbers here today that are actually very low in comparison with the United States. And most families don't have $10,000, let alone the $1,200 that was mentioned. So if we think about the prices that taxpayers are paying for this, it is $75 a day to hold someone in jail pre-trial. But it's only $7 a day to supervise someone in their own community. I do hope that we would continue to look into supervisory methods that are not user-financed. There are some really lucrative ways that people are being taken advantage of, and really allow people to receive these things called ability to pay hearings. So this goes back to that pre-trial risk assessment that I was speaking to. As was mentioned, the City of Atlanta has a pre-trial diversion and pre-arrest diversion program that are going really well. So I hope that we can study this issue further and would answer any questions the committee has.
Any questions from the committee members? Yes, sir. Chairman Jasper.
Representative, I just had one question. On line 7, you talk about 64% of those incarcerated in jails. Are those misdemeanor, or are those including felony incarcerations
This
also?
is misdemeanor. It's not? I thought it was. Excuse me, it's both.
So what would be the number for misdemeanor cases that are incarcerated and not been convicted of a crime?
Right. The 64% came out of the commission of the 64% of the individuals that are in jail that have not had a trial. That's where that number came from. What we are looking to do is to study this issue to really get down to that number that where you were saying, so we could really get a good number on what it is costing Georgia to keep people in jail that really we could, they could be out with a signature bond or something like that. So that's the whole point of bringing the study committee, because we believe there's more research that needs to be done on this.
Well, I was just trying to make sure the accuracy in what was in this resolution was reflected.
Of what we're requesting, but it's
Well, I know that-
64% of the individuals that are in jail who have, there are 64% of individuals that are in jail that have not had a trial.
Well, certainly, and I understand
Yes.
that, but I'm just saying, you're really talking about, it seems to me, about misdemeanor cases.
Absolutely, but again, we wanted to present some legislation, but we just knew it was too involved to do it while we were in the session, which is why we're hoping that we be granted the opportunity to do the study committee, so we could really study this and look at what these numbers really look like and how it really affects Georgia, and from a budget standpoint as well as a safety standpoint.
Okay. Thank you, Mr.
Thank
Chairman.
you, sir.
You're welcome. Ms. Frazier.
Yes, sir. Thank you, Mr. Chairman. Representative Carter, thank you so much for bringing this bill before us. I have a question. We talked about the financial part, on how much it costs for a constituent to be incarcerated. Can you give me, I heard the number $75. What is the average cost per day to house one of our constituents? And maybe Ms. Dobson might be able to answer this one, Mr. Chairman.
So now, she can give us some more detailed information, but from an article that we have that shows like in City of Atlanta in 2006, there were 890 people that were transferred from the city jail that couldn't pay bond, and it was upwards of 9,000 hours and cost around $700,000. But Ms. Dotson can give us a little more information.
So it depends on which facility and which county, but they can range from about $50 a day to about $80 a day. So we know, like in example in Fulton County, it's about $77 a day.
So if we do the young man that you said had been incarcerated almost 3 months, time that,
Exactly.
and their fee was probably $300, it is
Exactly.
a numerous cost for the taxpayer.
That's right. Absolutely.
Thank
Yes.
you.
And I just want to add that one of the gentlemen that was incarcerated because he didn't have the money to pay his bond, he was disabled. He actually lost his income while he was in jail. So now we have someone that has some income that now may be back on public assistance because he was held in jail upwards of 2 months. Again, this is why we really need to study this issue.
Thank you.
But you want to speak, so we will get out your way.
Okay,
You're
that's good.
smiling, so I think that's a good thing.
Thank you. Thank you, Mr. Chairman. I didn't plan to speak on the bill, but I heard some information that I really wanted to clear up. And my name is Scott Hall, and I was been actually very active in a lot of these cases across the country. The City of Calhoun case that was filed by Equal Justice Under the Law is actually still under appeal. It's being appealed in the 11th Circuit Court of Appeal for the second time. and will probably be heard sometime the second week of May of this year. The city of Atlanta, I'm glad they brought up that case, because the most important thing you need to understand is these people are not in jail because they lack money. They're in jail because they're accused of committing a crime, okay? And the individual that Maritza spoke about, the city of Atlanta, that they thought was such a good individual to bring up, this poor, you know, homeless individual. In 2008, he had 4 charges of disorderly conduct. In 2011, he had a criminal trespass, disorderly conduct. 2015, 2 charges of criminal trespass, 1 charge of disorderly conduct. In 2016, he had 4 charges of theft by shoplifting, 1 charge of simple battery. And in 2017, 2 charges theft by shoplifting, 2 charges violation of probation, 1 charge of possession of cocaine, 1 charge of violation of family violence, 1 charge of criminal trespass, 1 charge of simple battery and fighting words. And this is the individual that the Southern Center thought would be a great individual to put back on the street, which they did. Okay? And where did he go back? Back to Fulton County for possession and selling drugs. Okay? Now, I'm here to tell you as a taxpayer, this is why we have jails, is to protect me and my family from these individuals. Okay? There are exceptions. I support the study. Okay? I support this bill because you're getting bad information. 64% of these people are not in jail because they're poor, because they're there because they've committed a crime, and many of them have been convicted previously, and that's the reason they're not getting out on minor charges, because they have holes for violation of probation, okay, for other agencies. And if you ask any sheriff in the state of Georgia, they can tell you, ask them what's in their jail. They don't have an incentive to keep these people in jail. And they will tell you this is about saving money. Let me tell you what has happened in the city of Calhoun. They just published a study 2 years before this injunction, 2 years after this injunction. Bail is about one thing, and that is about justice for the victim, and you do not get justice for the victim without the appearance of the accused in court. In the 2 years preceding versus the 2 years after the injunction, you've had a 130% increase in failure to appear. Okay, you've had a 30% reduction in fines, fees, and forfeits. They talk about Harris County, Texas. Harris County, Texas, the appellate court, the judges are fighting this. They just won in the Fifth Circuit Court of Appeal. They were alleging that someone has a right to release just because they're poor. And they said, no, that has to be one condition of many. The reason they're fighting it so bad is because a full 45% of their court calendar is not showing up. Okay? In their infinite wisdom in the city of Atlanta, okay, they have in fact created a situation where somebody basically just gets released on misdemeanor charges. Now let me give you an example. I can go into a Lowe's or a Home Depot and steal up to $500, and now I will get a citation. Now if I don't appear on that citation, you're saying, well, there would be a bench warrant that would be issued. The city of Atlanta doesn't have a fugitive squad chasing misdemeanor defendants. They hope that some other agency might catch you. And if an agency, let's take somewhere like Hall County or Bibb County, let's say they accidentally catch you, they're going to contact City of Atlanta. You know what City of Atlanta is going to tell you? We won't go over 50 miles to bring them back so that the victim gets justice. Okay? That's the infinite wisdom of what City of Atlanta just did on criminal trespass, on shoplifting up to $500, on refund fraud. You know what refund fraud is? I steal a $500 toolbox from Lowe's. I don't pawn it. I carry it back to Lowe's so I can get 100% of my money back. And they catch you. Okay? There's a reason these people are charged with crimes. I fully support getting the data, because some of the data that is being given to you is being misconstrued. I do believe we need data. I do believe if there are individuals that are there, that are first-time offenders, that are there for reasons other than money, okay? We need to figure out a way to get them out, because as a taxpayer, I don't want to waste my money there. But many of these individuals are there because they are charged with committing crimes that have victims. And the very community that they're advocating on behalf of is in fact being victimized twice. Because if you're a single mother that had your purse stolen, okay, that had your rent money in it, okay, they broke out the back window of your car. I'll give you an interesting statistic. California, okay, San Francisco, the last 7 years, and I'll provide any of this data to the committee, 81,000 smash and grabs in the car, okay? 81,000. You know how many arrests, not convictions? 13. 13 out of 81,000. I'll give you another interesting statistic. You don't want to know the number one place in the country to leave? People are leaving faster than they are coming anywhere else? San Francisco. Okay? A U-Haul from San Francisco to Vegas right now costs you $2,000. It only costs you $100 to come back. Okay? This is not all about criminals. We need to keep in mind that these crimes have victims. Thank you. Yes, sir.
I'm gonna wait at this time.
Thank you, Mr. Chairman. Representative Carter, you had mentioned a signature bond in your previous statements.
As an option, not a solution. I
As
think
an
we want,
okay.
no. I'm not coming to you with answers. I'm coming to you saying that we have a situation that we should study, and I think everyone that's spoken, whether you're for it, but you brought a different perspective, and we know that this is huge, and we have to figure out what's the real problem. How do we put common sense legislation around it to be able to fix it? And at the same time, the gentleman that you were mentioning with the long arrest record, at some point we had to figure out what's going on so that we can keep some of these people from repeating and maybe stop some folk from perpetrating crimes if there are opportunities to do some community engagement. So again, the important thing that I'm asking for is the opportunity to study and engage professionals who are in the industry to be able to sit down at the table and get good data. I hear you. Good data so we can make good decisions and have good legislation. That's my objective.
And I would, Mr. Chairman, if I may, I would agree with that. I would want to, I think the percentage earlier that we talked about, 64% of those incarcerated in jails in Georgia have not been convicted or have not been convicted of crime, that included felonies. I would like to extract that and find out how many are misdemeanors, because it's my understanding December 27th, 2010, Greg Favors was out on a signature bond. Greg Favors was pulled over by Trooper Chadwick LaCroix for a routine traffic stop. Now, I represent Trooper LaCroix's family. Mr. Favors murdered Trooper LaCroix. Matter of fact, my wife is kin to his family. So I would like to find out the percentages that we have are misdemeanors and those that are first-time offenders.
Absolutely.
And those that are out on bond. Mr. Favors had 18 prior convictions with misdemeanors and felonies. Matter of fact, he was the same month convicted of breaking and entering into a car. So to ensure that those individuals aren't out on the street, but maybe even find out those that are first time and
Yes.
truly probably could benefit. But I would like the data to find out those that don't need to be out there, like a Mr. Greg Favors,
Yes.
who murdered a member of my constituency, and those who aren't capable of doing that.
Absolutely. And that's why I'm advocating for the study committee, because that's data that we really need to be able to bring back. And again, so the way that I approach everything, I'm coming open, no preconceived ideas, because the data is what's gonna drive where we go for me.
Thank you.
Yes.
Any more questions for Mr. Chairman?
Yes, sir. Your name again, sir?
Scott Hall.
Scott Hall. Okay, I'm sorry, I didn't write it down, didn't remember it. So, Mr. Hall, when looking at this resolution, do you see anything in here you would like to add to define and get the information that you're talking about that you'd like to see in here? Because if I'm not mistaken, you said you were okay with the resolution.
I have no problem with the
Okay.
resolution. Obviously, I have some questions and concerns about the data that's in the resolution,
Sure.
which I
We
have an
agree.
issue with. But I do support gathering data as to who are in our jails and how long, and most importantly, their prior, not necessarily convictions,
Sure.
but prior accusations. Because we've got many people in these jails. Bibb County had
Right.
an individual arrested shoplifting 84 times. Well, at the end of the day, at some point, we need to protect the public from that person. He doesn't need a bond for any reason. He needs to stay away from us.
You very eloquently made that point, but I just wanted to give you the chance, if you had looked over this and thought that we needed to have something to make sure that you got your point across, that we did that for you.
Well, I think most importantly is we need to have on the members of that committee, we need, and most importantly, sheriffs and jailers and people that understand the population who's actually in their jails. Because when I've called the certain sheriffs and said, help me find these people, they can't find them. Okay, they're in there, but they're in there for reasons other than this minor misdemeanor.
Okay.
So,
Thank
any
you,
other
Mr.
questions?
Thank you, Mr. Hall.
Okay. Thank you, Mr. Chairman.
Mr. Chairman, I'm Terry Norris. I'm Executive Director of the Georgia Sheriff's Association, and we probably know the most about this issue and the least about it. There are about 143 county jails in Georgia. Every county doesn't operate a jail. That number goes up and down a little bit sometimes. There's about 39,000 jail inmates throughout the state. We pay for those ourselves as local property taxpayers. There's not a sheriff in the state that wants anybody in a jail that shouldn't be there. And we, over my 23 years of being with the Sheriff's Association, we've done jail assessments of jail populations on an individual basis a lot of times to try to help a sheriff clear some of the low-level offenders out. The 64% number is accurate and it's inaccurate. It's accurate, and I think this number came from the county jail report. The county jail report is a report that is submitted by jail staff to the Georgia Department of Community Affairs. The categories upon which they collect data are really broad. So this 64%, when I looked the other day, it was 62, but I think we're talking about the same number. That is a number of people awaiting trial, but almost half of those people can never get out because there is no bond set on them, because they're already under sentence for probation or parole. So they can't move them anyway. So that's a full, almost half of those people can't get out anyway. So to say that they hadn't been convicted of anything is not accurate. The remainder of those folks have not made bond. Some of those could have been misdemeanors. I looked last week at Walton County and Henry County, and that's where I came up with the 48% of these people can't get out under any condition unless the parole board or a judge lets them out off of a parole or probation hold. A lot of these people are in jails because of criminal justice reform. So we've got to figure out a way from our perspective, from the sheriff's perspective, to do a better job of defining who these inmates are. And I think Representative Carter, that's exactly what she's asking to do. So I didn't have much of a conversation today with my leadership, but I can tell you we talk about this bill, I should say, about this resolution. But we talk all the time about trying to figure out who is in a county jail. Smaller jails are easier But if you can think of it this way, in the early 1990s, this state legislature and the governor decided that state ought to be out of the supervision of misdemeanor cases. And we privatized that, and we also let local sheriffs and city and county governments have their probation services. Since that time, there's been a lot of other changes in the system. We've put a lot of people on the street. We've arrested a lot of people. A lot of these people that we're talking about now, not only are they on state probation, some of them are on misdemeanor probation in multiple jurisdictions. We really don't have any idea somebody's on misdemeanor probation unless it just happens to pop up in the county we're at. Because if you're 2 counties over, 3 cities over, we don't know unless there's a hold put on that person. So you could have someone serving 2 or 3 misdemeanor probation sentence, probated sentences, a state probated sentence, and there could be multiple holds on that person. So it's really a complex arrangement if you're really wanting to identify who's in jail and why they're there. We're going to do a little better job going forward to try to capture the inmate profile in our state, because we believe that a lot of what we're hearing in the media is incorrect as to who's in there and why they're in there. But let me assure you that the sheriffs do not want, again, I'll say this, they don't want anybody in that jail that doesn't need to be in there and that can get out. So we do things to clear it out. I'd like to support this resolution today. I'd like to do that with the request that a sheriff, a district attorney, and a solicitor general be added as a member of the study committee. I think it'll bring a lot to the table, and I think we will, we'll proceed into the next session with a lot more information on this matter than we have now. This is an important issue. It is costly in terms of human costs, in terms of financial cost to counties. If you think no further than the medical costs of keeping somebody in a jail, it's phenomenal. Mental illness is our #1 enemy. Make no mistake about it. And a lot of these people are on psychotropic drugs. Different jails, it was referred to earlier, Marissa, I think, said it. Different jails have different, certainly different inmate capacities, and they provide for inmates differently. And it is solely the responsibility of the sheriff to take care of those inmates. And it's done so with county tax dollars that we all pay. Mr. Chairman, that's my comments. Be glad to answer questions.
Thank you, Mr. Chairman. Question, Mr. Jackson, you mentioned adding those members to this study committee, but one of the things I'd like to see, and I think you can probably support this as well, I don't want to reach out there too far, but I think there needs to be some representation from municipal court judges as well, because a lot of these issues are dealing with specifically municipal courts. And
there is no question that municipal courts are, those inmates come out of municipal courts are the main people we're talking about.
Certainly. So I think that that'd be some vital information that could come from that. And I just say that, Mr. Chairman, from my background in local government, and that was one of the things that was very concerning to me, was the amount of money that our city was paying our sheriff to house some prisoners. And you get to looking at it, and it was petty anti-crime that we were paying $45 a day to lock somebody up who had stolen $100 worth of merchandise at Walmart. And, they were in jail for 15, 20, 30 days, and sometimes 45 days.
And that's where, Mr. Chairman, that's where if you can assess who you've got in there, who you've got in there, you can move these types of inmates out. I did want to say another thing, though, about texting people who are supposed to come to court. Look, people got to be accountable at some level. And I will tell you, we're 1,500 deputy sheriffs and jailers down in this state right now. We can't hire anybody. We can't pay them. We can't text anybody and tell them to come to court. Now, I can just tell you that. We're going to go ahead and have to agree on that today, ma'am. Okay. So that's the extent of that part. Can I say something about another issue real quick? On school safety, y'all. Well, school safety. Just as a footnote, we talked about a while ago on the other resolution by Representative Cox about finding ways to help offset the cost of school safety. Sheriffs across this state right now are contributing to school boards out of asset forfeiture money to help pay the cost of panic buttons and other matters. So I know there's a lot, we get beat on a little bit about that particular issue, but that is an important dollar that's being used in a very wise manner. So, Mr. Chairman, thank you. Members of the committee.
Any other questions? We have anyone else out here that wishes to be heard today? There you go. Discretion of the chair. This language, there's a lot of whereas's in here, and someone probably needs to be heard. Yes, that. Explain this to other people. That being said, Mr. Collins, Mr. Jaspers, I'd like for y'all to consider this resolution over next week. I'd also like to offer this bill, for your benefit, what I'd like to say is, there's not a lot of study committees that get done during an election year. So we're going to try to clean this thing maybe a little bit that might help it move forward. And at some point, if in the infinite wisdom of the legislative process this bill goes forward, you might find a bill, matter of fact, your bill number may be used or somebody else's bill number may be used. But there's a term, Christmas tree. You may see a lot of different possible study committees that'll be put into lumped into one bill. So I'm just going to prepare you for that at some point along the way. But if the three of you could work with Representative Carter, I'd be very grateful. Thank you, ma'am. If there's nothing else before the committee, this committee stands adjourned.